instruction penalty proceedings.
Excuse me, Your Honor, do you have a highlighted copy of the defense's instructions?
I don't.
Okay, that would be helpful because what the defense did, for the most part, was they highlighted in green the changes that they made, and they left in black the changes that were for the standard instructions. Now, they have changed some language in the standard, from the standard instruction that they did not put in green. They left it in black, but didn't indicate that they had changed the language. So I think the first thing you need, if you don't mind me saying, is a colored copy of what the defense has prepared.
I don't have it.
I have that.
Oh, you have it.
Yes. Do you guys have one, I assume?
Yes.
Do you have an extra one that you can give me? Thanks. I think I've told you all this. We don't have the luxury of
Right, that's why I brought it.
other copiers, right? Okay.
Judge, I also have printed out a copy from the website of the standard. Which, do you want this, or do you want just this book? I don't know if you have a book up there. Or the actual standard instruction.
I'd rather not. I'll use the computer because
Okay.
the book they changed.
Okay. Well, I printed from the website. I don't know if you want this. We have an extra copy of this also.
But that's not all of them.
No, this is just 7.11. The standard instruction from the Supreme Court website, 7.11.
Okay, I think I've read both sets of instructions, and I have the standard instructions in front of me. But I think the easiest way to do it is to take the standard instruction and go paragraph by paragraph and ask both sides to tell me if they have any proposed changes. Does that?
Works for the defense.
That's fine, Judge. I just have one thing I'd like to put on the record before the court begins that process, if I may.
Okay.
Judge, I'd like to turn the court's attention. There is case law, Stevens versus State, STEPHENS versus State, 787, Southern 2nd, 747 at 756, where the Florida Supreme Court stated that while a defendant is entitled to have the jury instructed on his theory of defense, the failure to give special jury instructions does not constitute error where the instructions given adequately address the applicable legal standards. The trial court in the instant case gave the standard jury instructions for first-degree felony murder. The standard jury instructions are presumed correct and are preferred over special instructions. That is from Stevens versus State, and more recently from the Second District Court of Appeal in 2020, Grant, G-R-A-N-T versus State, 311, Southern 3rd, 156, at 162. The standard jury instructions are presumed correct and are preferred over special instructions. Admittedly, the trial court does retain some discretion as to the use of standard instructions, particularly when there is a problem with a standard jury instruction or when a standard instruction is inappropriate in a particular case. However, if the trial court determines that a particular standard instruction is erroneous or legally inadequate, the court may modify or amend the standard instruction, but it also must state on the record or in a separate order the respect in which the judge finds the standard instruction erroneous or inadequate and the legal basis for varying from that instruction. This procedure is important because both the confidence in the use of the standard instructions is undermined when their use is rejected without explanation.
Okay, and my preference, as you all know, because we've dealt with some instruction issues, is to follow the standard instruction. I'm happy to consider arguments as to why I shouldn't follow it, but my opinion is that the standard instructions were drafted for a reason, and unless somebody can explain or convince me why the standard instruction should not be used, my preference is to err or to err on the side of the standard instructions. And I'm not sure if err is the right word, but you all know what I'm saying. Okay, so 7.11, final instructions and penalty proceedings. The first paragraph, is there any objection to the first paragraph? It appears both sides are in agreement that the first paragraph should be included. State?
Judge, I did include the paragraph as is, except when the sentence in the center of that paragraph, they say, imposed upon the defendant for the crime of first-degree murder. Because our case is very different from most cases, we have 17 counts of first-degree murder and 17 counts of attempted first-degree murder. I did change the wording to reflect that by saying the appropriate sentence that should be imposed upon Nikolas Jacob Cruz for the 17 counts of first-degree murder charge in the indictment. So the only change I made to that was to clarify that there has to be a decision to all of the 17 counts. And I think that would be an important aspect throughout the instructions and in the verdict forms, that there has to be separate verdicts.
And both sides have been in agreement that I should distinguish that there's 17 counts in this case. When I read the initial comments to the jury, I do think it should say each as to the appropriate sentence that should be imposed upon the defendant. Hold on, I'm sorry. For each of the 17 counts, they should distinguish the fact that to remind them that they have to impose a sentence of life or death on each of the 17 counts and not as a whole. Is there any objection to adding for each of the 17 counts?
No objection from the state judge.
Judge, we don't have an objection to that. However, the addition of charge in the indictment, especially if Your Honor is going to change it to say for each of the 17 counts of first-degree murder, they're not. That language, charge in the indictment, is not part of the
Where are you?
I'm sorry. So after 17 counts of first-degree murder, the state has added charge in the indictment, and I believe Mr. Klinger was saying to try to clarify that each of the 17 counts would have to be considered separately, that's why he put that language in there. And if Your Honor is going to clarify by saying for each of the 17 counts of first-degree murder, I don't think it's necessary for charge in the indictment, and it's also not language in the standard instruction.
Your Honor, the jurors will be able to see the indictment, and I think it just makes it very clear, again, that there are 17 counts of first-degree murder in the indictment.
By the way, State, are you going to be so kind as to when I indicate changes that need to be made, are you all going to do that, or
Yes, ma'am.
do you want my
I'll
office?
keep track of it. We can go ahead.
I know normally the state does that for the court, but technically it's my job. So if you want someone from my staff to do it, that's fine. I just have to let them know.
Judge, we have all of this in Word and on the computer. It would be very simple.
Okay, I appreciate it. All right, as charged in the indictment is going to remain in. I think that is for the jury's understanding and nothing more. All right, how about the second? I see the state has added the second paragraph. Each crime and the evidence applicable to it must be considered separately, and so on and so forth. Indicated at the bottom that the paragraph was added from the language 3.12, single defendant, multiple counts. I think that is a necessary addition.
Judge, we would be objecting only because we do not feel it is necessary. They've submitted 17 separate verdict forms. You will read off 17 separate verdict forms. You've now clarified and said each of the 17 counts. And on page 14 of at least the state's proposed instructions, it discusses again that there are 17 separate verdict forms.
Judge, Ms. Patchen is correct. I believe it's on the top of 15 in the state's instructions. But again, this is a very important point for the jurors to realize and to hear that there has to be these individual decisions made as to each count. And this paragraph also says that the crime and the evidence applicable to each count is what you need to look at for the appropriate sentence.
Ms. Bashman, why are you opposed to making it more clear to them?
Because it's said multiple times throughout. It makes no sense to continuously remind them of that. They're able to read and you instruct them properly, along with reading 17 different verdict forms. So I'm not sure why it's necessary.
Your Honor, if I may.
Over the defense objection, I'm including that. It's included for a reason. I think that normally in a first-degree murder case, and probably isn't 17 counts, so that option hasn't been added.
And for the record, Your Honor, this point is going to come up again and again, and I would cite to the record under Pangburn versus State, and it came out of this circuit, each victim is supposed to have its own verdict form, and it's error not to. Plus, under the Eighth Amendment, the defendant is entitled to individualized sentencing, and he has pled guilty to 17 counts of first-degree murder. So for those reasons, this issue is going to come up and up again. We have streamlined these jury instructions as to not make it repetitive, but this is an issue that the defense is going to keep objecting to, and the reason the state has put it in here is because of Pangburn and because of the Eighth Amendment. It is necessary.
Okay, so with that said, State, you're gonna take off the underlined part and take off the footnote.
Yes, ma'am.
Please.
Yes.
Okay, the third paragraph that begins, in making your decision, you must first unanimously determine. Is there any objection? That appears to be the standard language. Is there any objection from the state?
No, Your Honor, I believe I copied that.
Okay, is there any objection from the defense?
No, Your Honor.
Okay, so the green, so the standard language says the next paragraph should begin the aggravating factors alleged by the state are, colon, and then to list them. The defense has suggested that we say how many, first of all, Roman numerals are really not my preference, mainly because I am not good at them, especially when you get up to whatever XV11 are. My preference is to write the number. I know that's how you all do it in the indictment. I know that's how it's done. However, if we can, I'm going to assume that if I don't remember being taught Roman numerals in school, that maybe at least one of the jurors hasn't, and I would like to stick to numbers, actual numbers.
That's fine.
We don't want them fixating on that, because I would be going, what, it would give me X? I mean, I'm sure collectively they could figure it out, but why, right?
Sure.
Maybe I'm the only one that wasn't taught Roman numerals in school, I don't know. All right. So you're suggesting just that we say how many aggravating factors are alleged, the number?
Just so the way that, and the notice of intent to seek death does not reflect this. However, in subsequent pleadings, the state has indicated that all but 2 of the alleged aggravating factors apply to every count, and then 2 of the aggravating factors, the disruption of a governmental function and the elected or appointed official aggravator, those only apply to the 3 staff members. So the way we did it, just to make it more streamlined, is to say the aggravating factors alleged by the state for counts 1 through 17 are, and then list the 5 aggravators the state intended to apply to every victim. And then if you skip down a little bit, it says, and I forgot to put this one in green, that's my error, but on page 4 at the top, it says additional aggravating factors alleged by the state for counts 9, 11, and 12 are, and then the 2 that are only meant to apply to the staff members. Then I think that makes it pretty clear that they are alleging that the aggravating factors apply to every victim except those 2 which only apply to the staff.
I gotta tell you, both ways are confusing to me when I'm reading these. Let me just look at this again, please. So there are 2 alleged aggravating factors that only apply to 2 victims.
3.
3 victims, the teachers, the adults.
Yes.
That's 9, 11, and 12. The difference between what the state did and what the defense is asking to do is that we put at the end of each aggravator. So if you look at aggravator 1 and you go to page
Oh, I see.
4 at the top, you see this aggravator applies to all 17 counts of first-degree murder. And I'll tell the court in advance that the first aggravator has to do with the prior violent felony and contemporaneous convictions. And it's a more difficult aggravator to lay out than the rest of them. So we're starting with probably the one that's the most difficult to go ahead and get the wording correctly on.
I'm sorry. Will you repeat that, please?
Sure.
I was looking at the...
No problem, Judge. So the first aggravator in this case is the prior violent felony. And that can be proven through contemporaneous convictions, or it can be proven, as we did in this case, convictions for Sergeant Beltran in the other case defendant pled guilty to. This factor, more than the other factors, needs extra language because it's not defined very, very well in the jury instructions when it comes to contemporaneous convictions, because a lot of the times there's only one victim and there's not a whole, like we have here, we have 17. So, but before I get to that, the defense wishes to put at the beginning, the aggravating factors alleged by the state for counts 1 through 17 are, and we have chosen to follow this jury instruction, leave it as the aggravating factors alleged by the state are, and at the end of the aggravator, and that's on the top of page 4 for the first one, we wrote, this aggravator applies to all 17 counts of first-degree murder. But that way the jurors would hear the aggravator, and then they would hear that applies to all 17 counts.
Let me ask you all a question. Is there any reason why we can't put aggravating factors, number 1, and give whatever the abbreviated name for that aggravator is, put that in bold, then give the instruction and say this aggravator applies to the following? Like, in other words, when I look at all these paragraphs, I'm thinking this is sort of like a bullet point, like make a bullet point for them to know aggravator number 1. What is the abbreviated name for aggravator 1?
I think that maybe the way to do it, Your Honor, is if you wanted to bold the very first sentence, because that tracks the language, where it says Nikolas Cruz was previously convicted of other capital felonies or felonies involving abuse or threat of violence to the person.
Yes.
Because if you bold that, then everything that the state has drafted underneath it, under subsection A, tracks the other capital felonies, because they're contemporaneous convictions, because where there's one episode with multiple victims, those contemporaneous convictions count as prior felony capital convictions for purpose of this aggravator. And then the following paragraph, which it says the attempted, which were the non-homicide counts, also count as contemporaneous convictions. And then paragraph C, which relates to Deputy Beltran, is the second part of the first sentence that will be bolded. So that the jury will understand, as you're pointing out, that the aggravators are defined in the first bold sentence, and then everything else comes underneath it.
Is there any objection to doing it that way?
Yes, Your Honor.
Because?
So the objection is we would be fine with just saying this aggravator. So, for example, paragraph.
First, I'm just talking about bolding the first line so that they know it's sort of like a bullet point. Like the first aggravating factor is being previously convicted of other capital felonies or felonies involving the use or threat of violence to another person. So that they say, okay, that's the aggravator, and here's the definition of it. And then the next one, 2, with the actual aggravator being bolded, okay, here's the aggravator, and here's what it is.
Judge, we don't have an objection to that.
Just the bold part. Okay, so what is your objection?
Right. I mean, the objection is that the way that the state has it set up now is too wordy and confusing. Now, if you were to bold that first part, for example, paragraph 1, right? And then the crime of murder in the first degree is a capital felony, and then say underneath it, say this aggravator applies to all 17 counts instead of listing all of the counts, it would be clearer for the jurors. I mean, they've done that on other aggravators. I'm not sure why it was necessary to do it like this.
The reason that it's necessary is that if you have one victim, the other 16 apply to the one. So that's why you list it out.
I understand. So
there isn't a shortcut when there are 17 victims of a homicidal episode, Your Honor.
And I think the jury understands that there's 17 counts if you say this applies to all 17 counts.
And then you have 17 attempted first-degree murders. There really is no shortcut. You have 34 contemporaneous convictions, and then you have 3 priors regarding Beltran. I mean, we have 37. We have 37 prior convictions under aggravator 1 here. So we have to spell it out. We don't want a problem in the Florida Supreme Court. We don't want jury questions coming back about how does this work, because historically, this is where the jury could get confused unless they are explicitly instructed.
And Judge, I just respectfully disagree. I think this is very confusing how it's written.
Your Honor, in one of my cases with Judge Holmes, this actually became an issue. There was a juror question about contemporaneous convictions. So it has to be set out properly. In most cases, when there's contemporaneous convictions and you have maybe 1 or 2 or 3 victims, you would go by count. Each victim's count, you would have the aggravators listed underneath that count. So if you had 3 victims, count 1, it would read who the victim was, and then the contemporaneous would be the names of the second, the B person.
I don't disagree with you. I'm just trying to
So that's why we didn't
see
do
if
it.
there's a more clear way to explain this, because it's a lot.
Judge, did you want, after we bold that first sentence, to move the instruction, the court further instructs down, separate it out?
Yes, I think that should be the next paragraph. Please.
Yes.
Judge, underneath letter A on page 2, the crime of first-degree murder is a capital felony, right?
Okay.
And then when you go down and you read, I mean, I think they're going to get lost in reading, and I understand why the state wants to put all the victims' names in there, but it says the exact same thing. It just says lists them all. I mean, this doesn't say anything more than the crime of first-degree murder is a capital felony. It just lists out those crimes. I mean, or the victims' names. It says the exact same thing. It just says it in like 2 pages. Subsection B, the crime of attempted first-degree murder is a felony involving the use or threat of violence to another person. And then you go down, that paragraph says nothing more than that, except it just lists names. I mean, it's just repeating the same thing.
Your Honor, there's an alternative to what the defense is objecting to, and that is where you have multiple victims. And this is going to be redundant, and it's going to take a long time, but in the Hojan case in front of Judge Backman, there were 2 homicide victims, and I can approach the court and show you how I did jury instructions for that case, where each victim had the aggravators applicable to the victim listed underneath the victim. Now, that would take a very long time to read, because for each victim in our case would have 16 other victims listed for first-degree murder, another 17 for the attempted first-degree murder, and then the other 3 regarding Deputy Beltran. So
I'm not concerned about the length of time. I just, you all have done this multiple times. I don't think it's a surprise to anyone to know that this is my first death penalty case, and I am looking at these instructions thinking this is not extremely clear, and I have a law degree and I'm a judge. So I'm just wondering if there's no other way to make it more clear or more simple, then that's okay. This is how we'll have to do it. And I certainly don't think that, they need to understand that the consideration for the first aggravator is for each and every act that Mr. Cruz did, and each and every murder and each and every attempted murder. And certainly I don't want to downplay that there were 17 plus 17, but I'm just wondering if there is a way that it can be just a little bit more
Well, Judge, in the first paragraph, after the portion that we all suggested or that you suggested be highlighted, then there's this underlined part in the state submission where it specifically says, the court further instructs you that where a defendant is convicted of multiple murders arising from the same criminal episode and involves multiple victims, the contemporaneous conviction of murder in the first degree or attempted murder in the first degree as to one victim may support the finding of the prior violent felony aggravator as to the murder of another victim. And then they list the crime of first degree murder is a capital felony, and then on the next page, the crime of attempted first degree murder.
That may be clear to you as a lawyer, but that's not going to be clear to the jurors, I don't think. Leaving it just at that. All right, why don't we skip over this issue for now? I think that if you can, how long would it take you to type it up the other way?
You mean for each count?
It's going to take a long time.
Yes.
Can you do maybe one so we can see how it looks? No? Or do you want to show us the Judge Backman
I can, Andrew,
instruction to both sides so that I can just...
Now there were 6 aggravators, if I may approach.
Sure. I just want to see if visually this is... Thank you. Do you want to come look at this? Somebody? Have you all seen this?
I was going to send them a copy. I can send both the court and them a copy via email.
If I understand this is going to take a long time to do, however, if you assume that they're going to go through everything one count at a time, one victim at a time, I'm trying to put myself in the juror's shoes. If I have an instruction for each count, to me, that's a lot easier to follow. Do you all want to take a look at this? So basically it has aggravating factors for count 2, then it has the victim. So it would be for count 1, and then for count 2, and then it would list them. I think that is, and then bold the actual heading. To me, that is a lot easier to follow. And then they could actually go through the counts with the instruction.
So is it the full instruction?
What
For
take
each one?
Why don't you
emailed it to you.
why don't you take a look at it?
I forgot my computer. Sorry.
Whatever your preference, John.
And that's going to be like hours of work, right?
Well, if we have someone start on it now, it can be done. It's going to take a long time to instruct the jury, depending upon, I think what time did you want them back tomorrow morning? Was it 8:30?
Mm-hmm.
It'll take several hours to read it, but it can be done.
Again, so for each count, you would be reading the 16 names for for first degree murder and the 17 names for attempted first degree murder. For each of the 17 counts. That was the reason why we changed course in this case, in this particular, this set of instructions. But that can be easily, we can change it.
I mean, if I was a juror, I think that way is a lot easier to follow. But again,
What we can do is we can print up one, so you know, it applies to this case exactly. And you can see how it looks.
you see how each count is, the aggravators for each count are listed. Michael, did you see it?
What we have with doing it that way is the prior violent felony aggravator is 1. It's sort of like possession of ammunition by a convicted felon. It's 1 count. If you had 5 different types of ammunition in your house and you're a convicted felon, it's not 5 counts of possession of ammunition by a convicted felon. This aggravator, they find 1 prior violent felony, it's 1 aggravator. Okay? They don't get it 17 or 16 times, 17 times. So the way that they're describing to do it, not only will take the entire day, but it's also, you're going to lose these jurors after a while, and it's misleading in the sense that it makes it seem like it's 17 aggravators, and it isn't. So, I mean, I'm not thrilled with the way that they did it in the original, but it's certainly better than the alternative that has just been proposed. And I think maybe there's just a way, I mean, maybe we can take that second sentence that's underlined and make it a little bit less confusing to read for the jury, and then just instruct them a contemporaneous felony or contemporaneous conviction for murder or attempted murder may support the finding, and then just tell them that it's, I mean, we're saying this now 4 times, which is fine, but I think it's too misleading the other way, and it also makes it seem as if this is an aggravator that applies 17 times.
It does. It applies to all 17 counts.
Right, but it's 1 aggravator. It's not 17 aggravators.
Well, actually, it's 36 different violent felonies.
Because they could find that the murder of Luke Hoyer, Gina Montalto, and Alexander Schachter do qualify as an aggravator, but for whatever reason, the 3 other victims don't. Could they not?
But then it wouldn't matter, because then it would be proven. It's 1 aggravator. If they don't find it for everybody, it doesn't make a difference. Or if they decide they didn't think the Sergeant Beltran case was a prior violent felony, if they find even 1 murder, other murder, or attempted murder, the aggravator's proven. It's not that they can find this and have it apply 17 or 30 whatever times.
Yes.
It's 1 aggravator, just like possession of ammunition by a convicted felon. It's 1 count. Doesn't matter if you have 1 bullet or 1,000 bullets. It's 1 count.
Judge, it does matter because this is about weight, not counting. So you could have 1, it is 1, Ms. Curtis is correct, it is 1 aggravator, but is it the size of a pebble or is it the size of the sun?
Okay.
And the more convictions, it makes it a more weightier.
All right, but I'm going to keep it the way the state originally proposed. However, is there any objection to me only reading the name and not the count unless you want to put the number, the actual number? Can you put the number in a parentheses? In other words, XB11, paren 18?
We've already changed. We've changed it to the actual, just the number, 1,
Oh,
number 2.
perfect. Because I know you're mirroring what's in the indictment.
Right.
So I don't know if you wanted to keep that. But for purposes of making it a little bit easier on me and maybe some other jurors, putting in parentheses just 1-8 or 1-9. See what I'm saying?
I see what you're saying. So for the Roman numeral II, it would be in parentheses 2.
Correct. Please,
Sure.
if you don't mind.
No problem.
Judge, I do have objections to the Beltran charges.
Okay, hold on just a second, please.
I just want to make sure you didn't move on.
Also, okay. What I would like to do is, do you see on page 2, you have a paragraph that describes aggravating factors, then you have aggravating factors. I would like all of the pages that deal with aggravating factors to say, like at the top, aggravating factors, page 1 of 10. Do you see what I'm saying? Aggravating factors, page 2 of 10, 3 of 10. That way, the reason I like to do that is, let's just say in another case where there's an instruction that goes on for multiple pages, if these pages get And now I know you have page numbers on the bottom, but still, if they want to separate out specific instructions, they can do so in the back.
Okay.
Does that make sense?
Move it to the top, or leave it where it is, but also put on the top.
I think leave it where it is and then also put it on the top. Aggravating factors definition, or aggravating factors page 1 of, on the top.
Is there still going to be a page on the bottom?
For now, let's leave the page on the bottom. Or maybe I just don't normally have pages on the bottom. It's been a while. Nicole? We don't have pages on the bottom? I just want to leave the page numbers on the bottom. I want it to be clear for them that every one of these pages deals with a definition of an aggravating factor. When we get to the mitigating factors, same thing. That they know they don't have to be really trying to study these to figure out what goes with what, even though there are page numbers. Okay, Ms. Basham, you were saying?
Yes, Judge. So for paragraph 1, C, D, and E.
What page are you on? Let's definitely leave the pages for today's purposes, making it easier.
The bottom of 3 into 4.
Okay?
3 charges stemming from the Beltran case. And I just wanted to renew our previous arguments that we made in DP 50, which is the motion to preclude use of conviction in case number 18-14129 CF10A as an aggravating factor under 921.141 subsection 6 subsection B. And we would also like to say that even if it should, these charges be submitted to the jury for consideration as an aggravating factor, that we would like an instruction to the jury that would allow the jury to decide if these crimes are ones that constitute threat or violence to a person.
Okay, your argument is preserved, but your request is denied. We've had argument on this issue previously. Okay, so we're going to bold the number 1s. I also think that the A, B, and C and D and E should be bolded.
Judge, I'm sorry, if we could go back to E on number 1. I don't know that I may be remembering incorrectly, but maybe we could pull the actual exhibit, because I thought it was only the 2 convictions that were used and that the rest was like taken out.
Well, what the misdemeanor wasn't included, but that was.
I didn't think that depriving the officer of a means of protection was.
I don't remember.
It's my recollection it was, but we could look at the.
Sure.
Yeah, I don't remember.
Evidence, I believe it was, but.
Okay.
What was does anyone have the case number offhand?
18-14129.
014129.
Judge, I'm talking about the,
Right.
in evidence, what we did, what the court ruled is what.
I ruled the felonies qualified, the misdemeanor did not. I was just going to look up the case number to see which one was the misdemeanor.
Right, I just thought maybe we might not have included this count, even though it is a felony count. I don't know that we included that in the, if we could just maybe pull the exhibit and take a look at it. But it doesn't have to be right now. We could, if we are correct, we can just omit that, but if not.
Do you know the exhibit? We'll get the exhibit number.
It's
Conviction,
Beltran.
Beltran. Sergeant Beltran conviction.
I have the exhibit number. I have the exhibit number.
What's it?
480 would be the judgment and conviction, and 481 is the disposition.
It was attempted use of. Oh, I don't remember. All right.
Judge?
Hold on just a second,
Okay.
please. Okay, what were you saying?
I just wanted, so that we don't have to do this with each one, we, in the pleading that we filed, the footnotes for each of the aggravators renew the objections that we made previously as to the constitutionality and all of that of each of the aggravators.
Okay.
We can move on and deal with that issue about whether this was included in the exhibit or not
I just don't
later.
want to forget. Are you looking it up?
You want me to go get it?
Can you,
Have to call them.
please? All right, if you move on to page 4, the aggravator, so you're going to bold all of the aggravators.
So on page 4, with Nikolas Cruz knowingly created a great risk of death to many persons would be involved.
Please. And then number 3, the first degree murder was committed while Nikolas Cruz was engaged in the commission of a burglary. And then I read the definition of burglary. Is there a reason why that's in underlined?
I added in the definition, Judge. It wasn't in the standard.
Is there any objection to adding the definition of burglary?
No, Judge. However, we want to make sure that obviously the underlining comes out, and then I think first degree murder might be italicized. I'm looking at 2 different copies, so.
Burglary is defined as the entering of a structure without the permission or consent, owned by or in the possession of the Broward County School Board, and at the time of the entering the structure, Nikolas Cruz had the intent to commit the crimes of first degree murder. Okay, so we're going to take out the underline and the italicized.
Right, and we would ask that for, unless the standard instruction has something italicized, we would ask that, because that's just to highlight something. So we would ask that any underlining and italicized words,
And
or
the
italics be removed.
and the footnote on the bottom needs to come out too. Then paragraph 4, the first degree murder was especially heinous, atrocious, or cruel. That part should be bolded. Then I'll read the definition of heinous, atrocious, or cruel. Paragraph 5, the first degree murder was committed in a cold...
I'm
Yes?
sorry. We have an objection
Okay.
to where under the first degree murder was especially heinous, atrocious, or cruel. If you go down to the paragraph that starts the kind of crime,
Okay.
intended to be included as especially heinous. In the state's proposed, they don't have the word especially, which is the proper verbiage.
Okay, hold
for
on a
that
second.
Aggravator.
So the standard instruction state, I think you just left out a word. I don't know if you did it on purpose, but the kind of crime intended to be included It should say the kind of crime intended to be included as especially heinous, atrocious, or cruel.
I left out included as.
Kind of crime
Included as a special.
intended to be. I think you left out after B, intended to be included as especially. Those 3 words.
Yes, I'm sorry about that one.
That's okay. So you're going to add those?
Yes.
Okay.
Judge, I also have another
Go ahead.
question. First I'll start with at the end of that paragraph, it says unnecessary torturous to decedent.
Hold on one second. It says,
I'm talking about the standard instruction.
all right, I'm looking. Hold on. Okay. I'm where you are.
Okay, so we would request that be changed to decedent and for the counts to not be listed out. We already have them listed out now on paragraph 1. And underneath that paragraph where all the counts are listed, it says this aggravator applies to all 17 counts of first-degree murder, which I think is very clear. I understand what the state's argument was as to the prior violent felony, but it's very clear if you say to the decedents, this aggravator applies to all 17 counts of first-degree murder, and it's unnecessary to list the victims' names again.
Judge, it's in parentheses, and that means it needs to be filled in. Normally, again, when we go back to just having one count.
I understand. I agree that the decedents, you don't say decedent, you say the person's name. However, take out the count 1, count 2, and I'll just read their name. Please.
Okay.
And then rather than saying the aggravator applies to all 17 counts,
Judge, if you're going to read each of the names, then maybe we could just take out the aggravator applies to all 17 counts.
For clarity's sake, at the end of each one of these, we were saying what the aggravator applies to. Especially when you get to 5, 6, and 7, it only applies to 3 of those.
I understand. All right, you leave that part in because we've been doing that for each count, but just each aggravator, but take out the number, please. Okay, paragraph 5 on page 5. The first-degree murder was committed in a cold, calculated, and premeditated manner, and so on and so forth. That should be in bold. Then I will define cold, calculated, premeditated.
Judge, this is the standard instruction. We don't have any objection to it. Number 5.
Okay, number 6. The first-degree murder was committed to disrupt or hinder the lawful exercise of a governmental function or the enforcement of laws. And then if you would please put after each Roman numeral in parentheses the actual number.
They'll do that.
Judge, we would just make the same. I mean, given the court's rulings on the previous aggravators that we didn't want it done this way, we have the same objection, but given that that's how we're doing it, we don't have any additional objection to the way that this is worded.
Okay. And then number 7, bold, please, and then,
Judge, we do have an objection to number 7.
I'm sorry?
We do have an objection to paragraph 7.
Okay, what is it?
So as written in the standard instructions, it is decedent, was an elected or appointed public official engaged in the performance of his or her.
Let me get to the standard, please.
And it would be paragraph 11, Judge, in the standard instructions.
Okay, I'm on the standard, I'm on the state's. So it's the state's paragraph 6, the standard paragraph 11, and what is your objection?
Okay, so our objection is that this is not the full standard instruction. That's the first objection. They are leaving out elected or, and it's misleading because the full language is illustrative of what the aggravator is for, which is the intentional murder of a political figure. Also, where they say the victim was an appointed, so we would request.
I'm sorry, I've lost you.
Okay.
I'm trying to read yours, theirs, and the standard. And
So
we're on paragraph 6 of the state's proposed, or 7?
7.
Okay, will you just summarize your objection again, please?
Yes, it's not the standard instruction. They've left out and elected, which is the instruction.
The instruction should read, the victim was an elected or appointed official engaged in the performance of his official duties if the motive for the first-degree murder was related in whole or in part to the victim's official capacity.
Was he elected or appointed?
Well, and that's a point of contention, Judge. We're also objecting to the language after, and we're asking that it simply say, this aggravator applies to the first-degree murders of count 9, Christopher Hixon, count 11, Aaron Feis, and count 12. It's for the jury to determine whether they're appointed officials. We do not agree with that they are appointed officials. They're hired staff at a school.
Okay, but is there any evidence that he was elected?
No.
So why do we need to put that in there?
Because that clarifies the purpose. The reason that we're saying that this aggravator doesn't apply to them is because this aggravator was designed to aggravate murders of political figures or, because of, like Robert Kennedy, for example. It's not for a school shooting where a teacher is murdered. That's our position. They are not appointed or elected, and the murder was not for the purpose of, so we're asking that the jury not be instructed that they are appointed public officials engaged in the performance, that we just use the exact language from the standard instruction, and then just say, this aggravator applies to the first-degree murders of, and let the jury decide.
Well, the jury's going to have to
whether it
decide whether it is or not, but you don't keep language in an instruction where there's no allegation that particular language is true. The state still has to prove this beyond a reasonable doubt, but why would you keep elected if there's no allegation that he was elected? That's like...
Because, Judge, it puts the aggravator in context. There's no definition or further instruction on this. It's going to be for the jury to decide. And if they read the actual instruction, which was an elected or appointed public official, then they may determine, oh, this doesn't seem to be the kind of thing this is meant to apply to. When you leave out the elected part, it's misleading in the sense that it doesn't really capture the essence of this aggravator.
Your Honor, if I may be heard on this.
Sure.
Your Honor, in the course of, where it lists all the sexual battery, aggravated child abuse, arson, burglary, you don't read all of them and then let them choose. You read burglary for our case. You don't confuse the jury. And there's also case law to support the premise that you don't, shotgun it where you read everything to the jury and then argue that, well, this doesn't apply and that doesn't apply and this doesn't apply. I can find a case if you want me to read it into the record, but that's what the law is. And that is what the defense is asking you to do. They have been asking not to mislead the jury, and yet they want to leave in the word elected official for this jury instruction, when clearly we know that these adults who were murdered by the defendant were not elected. And we've already had the argument where you ruled that this aggravator applied to these victims.
All right, is there any other objection to number 7?
Judge, I just wanted to add one thing. Ms. McCann had stated that you don't put language into an instruction that doesn't apply, and she listed, those forcible felonies that in the standard instructions are considered in parentheses showing this is what you would pick, one of these, 2 of these, but it's not the actual language as is paragraph 11 of the standard instruction.
But you all are in agreement that there's no evidence that he was elected. And there's no allegation that he was elected.
Right, we agree with that, but
you want me
we
to
also
instruct them?
find no evidence that he was appointed. So that's the problem.
Could you repeat yourself?
I'm sorry. There's no evidence that they were elected or appointed. That's the problem. And the problem is by not reading the actual instruction the way it's written, it gives it a meaning that's not its intended meaning. And so we're objecting to leaving out the word elected because that word, even though there's no evidence that these victims were elected officials, it puts in context what the purpose of this aggravating factor is for, and we believe that the state has not proven this aggravating factor, that they are elected or appointed, and so to leave out that word misleads the jury.
All right, I'm going to overrule the defense objection. I'm going to order that 7 stay the way it is.
Judge, so are you also saying that the language underneath for count 9, Christopher Hixon was an appointed public official engaged in the performance of his official duties? Because we're not agreeing to that. That is for the jury to decide whether they're...
These are aggravators that have to be proven beyond a reasonable doubt. I'm going to assume that you're not agreeing to any of them. Isn't your argument that they're going to be that the state didn't prove their case?
No, but...
It's not?
Well, I don't know what our argument is going to be at this point, but my point is, the way that this is written, you are instructing them that Christopher Hixon was an appointed public official. That's different than defining what cold, calculated, or premeditated means. This is you telling this jury that Christopher Hixon was an appointed public official.
Okay, I've heard your argument. We're going to have to agree to disagree, all right? Thank you. Over the defense objection, 7 is going to say the same, the way that it is proposed by the state.
And Judge, we will bold the first.
Please.
And also, would you want the actual number after the Roman numeral?
Please, if you can put it in parentheses.
Yes,
Now, the next paragraph on page 7 in the middle of the page, that starts... Okay, so that's still part of aggravating factors, it's telling them what they can't consider as an aggravating factor. Is there any objection to the middle paragraph? State?
Judge, is that the paragraph regarding victim impact?
Yes.
Yes, we have an objection.
Okay, what is it?
Anywhere that it states evidence, we would object to that word and would request to use testimony. And we would renew our arguments that we made in DP 39, which is the motion to preclude use of the term evidence when referring to victim impact statements or information. It's misleading to the jury as it cannot be considered as an aggravating factor.
Okay, I think it's the state, is it the standard language?
Yes.
Yes.
And then also, Judge, we would object to the listing of the victims' names, but again, based on the court's previous ruling, we would just make the same objections.
Now, state, I could be mistaken, but I don't believe that, was there impact testimony for each of them?
Yes, Your Honor, every victim in this case, each family gave a victim impact statement.
Okay, I just want to
And
make
the
sure.
instruction clearly leaves a place to insert the victim's name.
Okay, thank you. So, over the defense objection, I'm going to give the standard language in the second paragraph of page 7. How about the final paragraph that goes from page 7 to page 8? Is that the standard language, state?
Yes.
Is there any objection?
I'm sorry, can you move on?
And actually, my question goes to the remainder of the aggravating factors instruction, because it looks to me like it's all of the standard language, starting with the paragraph as explained before the presentation of the evidence.
That's all the standard language. Up and through two mitigating circumstances.
I'm sorry, Mr. Klinger?
Until we get to mitigating circumstances, and that was all the standard language that was for aggravation.
Okay, so there's no objection to the remainder of aggravating circumstances.
Well, Judge, we put in our version, and it's on page 4, some language we would like. The paragraph starting with a finding that an aggravating factor exists, and that would be on the state's version, the last paragraph on page 8. We would ask that the beyond a reasonable doubt be added. A finding that an aggravating factor exists beyond a reasonable doubt must be unanimous. That is the standard. And then at the, well, I don't know, are we also moving on to page 9?
I'm listening.
Okay. If we're going all the way up through the mitigating circumstances heading, we're asking that a sentence be added after the very last paragraph, because it doesn't explain that the jury has to unanimously find that the aggravating factors are sufficient to justify the imposition of the death penalty. So we're just asking that a sentence be added, and we have it included in our on page 5. We would ask that it say specifically, you must unanimously find that the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify a possible imposition of the death penalty.
Judge, that comes later in the instructions after mitigating circumstances. They're skipping ahead. At this point, it's just for the jury to determine that an aggravating factor exists. And then we're moving on to mitigation. So at that later in the instructions, we'll be talking about the sufficiency of the aggravators. It's not the place for that sentence to be.
All right, I'm going to give the standard instruction. I think it's sufficient, I think it's clear, and I'm going to give the standard instruction. All right, moving on to mitigating circumstances. State, if you can do the same thing for mitigating circumstances, please. In other words, start it on its own page, and at the top put mitigating circumstances page, whatever it is, one of however many, and do that on the heading of each of the pages.
Yes, ma'am.
Judge, I'm sorry, before we start going through that, can I just run to the restroom real quick?
Sure.
Okay. Can I go back here? Unless,
I don't know if...
oh, I can just go
Oh,
out here.
there's no jury, it's fine.
Well, there's nobody out here either. I can just go out here. I'll be right back. Thank you.
think that the way that it is in every other case, non-capital, is much more clear for the jurors. So they say, okay, here's the rules for weighing the evidence, as opposed to just pages and pages of paragraph and paragraph and paragraphs.
I have no problem with that, Judge. Would you also want it, so then when we start with weighing the evidence, bold it, capitalize it, put it into the center of the, and then above, would you want the page numbers?
Yes, if there's more than one, I like there always to be the page weighing the evidence, page 1 of 2, weighing the evidence, page 2 of 2.
Okay.
What is weighing the evidence? 7 point... Here we go, 3.9. So,
Yes, sir. Okay.
Mr. Sequel, would you pass this to Mr. Kleiner and just, you can show it to your lawyers too. This is what I'm talking about. Just how it says it at the top of the page. You all have seen this 1,000 times. For whatever reason, in the penalty version of the instruction, it doesn't have it that way, and I prefer it that way for each of the subsections. Okay, so on page 9, mitigating circumstances, we'll start a new page for that instruction. Paragraph 1, under mitigating circumstances, is there any objection by either side?
And this is standard instruction.
No. You're talking about if you do unanimously find the existence.
I'm talking about what I assume is the standard instruction, first paragraph under page 9.
Yeah.
There is an objection?
No, no.
Okay. The second paragraph, it is the defendant's burden to prove that one or more mitigating circumstances exist. State, is this the standard instruction?
Yes, ma'am.
And defense, is there any objection?
So it's laid out in our version. It's red, crossed out. We put a proposed sentence in green, and I put in the footnote 10, the reasons. So we don't need to rehash that. It's all in our.
All right, I'm going to read the standard instruction over the defense objection. Now, on page 10, among the mitigating circumstances you may consider are...
Your Honor, I originally had taken the list that Ms. Curtis had provided us in an email.
Okay.
But then, the mitigation is their thing, and so I took it back out until we decide exactly what they want and what the court allows.
Okay, so I'm going to refer to page 6 of the defense proposed instructions. It says, among the mitigating circumstances you may consider are, 1, Nikolas Cruz is a human being.
Your Honor, if I may be heard on that,
You may?
that the case law goes both ways on that. There's a Florida Supreme Court opinion that says that it is not a mitigator, but there's other Florida Supreme Court opinions that say it is a mitigator, but it is given no weight. There's no Florida Supreme Court opinion that gives it any weight. So in an abundance of caution, you can give it as a mitigator, but it will should not be given any weight.
So what should I tell them? This is a mitigator, but don't give it any weight?
No, you don't tell them that. It's for the jury to decide what weight to give it. And I'm sure the defense will be arguing that the defendant is a human being, and they can give it whatever weight they want and weigh it. They'll look at that in comparison against the 17.
Okay, so you have no objection to me advising them that some of the mitigating circumstances are that the defendant is a human being?
There's really very few, Your Honor, that the state will be objecting to. We can make this a lot shorter if we just...
Sure, why don't you just tell me which ones you're
I'll just
objecting
tell you. So the other one that the state is objecting to...
Wait, you're not objecting to one, though?
Not objecting to one.
Okay.
And we'll go all the way down the list until 14.
Okay.
Nikolas Cruz's birth mother died very shortly after her birth. And
died... Nikolas Cruz's birth mother died very shortly after he met her.
After he met her. And the state would object to that based upon the case of Beasley versus State 774, Southern 2nd, 649, Florida 2000, which states, Your Honor, that a death of a family member that occurred after a homicide is not mitigating.
Is there any scenario where a mitigating circumstance could be something that arose after the crime was committed?
The defendant's conduct while he's in prison, while he's in jail, can be considered mitigating under Skipper.
Okay.
But there's a case from the Florida Supreme Court, and in contrast, because the impact of his father's death could not have affected Beasley at the time of the murder, when viewed in this context, the trial court did not err in failing to consider it as mitigation. And that's the Beasley case from the Florida Supreme Court, because they draw a distinction between what affected a defendant at the time of the murder versus after the murder.
Judge, we haven't had an opportunity to look at the case, but just based on what Ms. McCann just said, she said the court didn't err in not considering it. This is a jury that's making this decision, and if a jury finds that mitigating, then that's for the jurors to decide.
All right, I'm going to defer on that. I want to read the case. And what is the other one state that you're objecting to, or the other ones, the other factors?
Then going down the list, Your Honor, would be skipping to number 26K, where they say Nikolas Cruz was diagnosed with the following during his life. K, rule out autism. The state objects to that. It says rule out autism.
It's not a diagnosis.
He was not a diagnosis, and we object to that.
Defense?
Well, Judge, this did come up in a few of the records that we put in evidence. We could maybe think of a different way to phrase this, but I mean, this was...
Well, a rule out is not a diagnosis.
I understand it's not a diagnosis, so we can move it and say that several providers believed he had symptoms consistent with autism or something like that. It's important because autism sometimes co-occurs with and is mistaken for fetal alcohol spectrum disorder, or the other way around. So we want to keep that in. If we want us to take it out of this section and put it in a different way, we can do that and send it.
All right, I don't think it's appropriate for being diagnosed with certain things, so I'm going to sustain the state's objection, take K out, and if you want to propose another paragraph where it may be relevant or fitting, you can let me know.
We can do that.
All right, what else, state?
The next one, Your Honor, would be number 38. Nikolas Cruz will be punished in prison and society will be protected. The state does not have a problem with saying that Nikolas Cruz will be punished in prison, because there is case law that supports that a life sentence could be mitigating. But to say that society will be protected, society would be protected if he is executed as well, Your Honor. So the second part of that mitigator is not applicable.
Plus, aren't the other prisoners considered members of society?
Yes, and so and we know what has happened when he has been incarcerated. So the state has no objection to the first part, that he will be punished in prison, but does object to the second part of the 38, the mitigator. Will be punished by being in prison. Maybe that's a better way to say it. I don't want to tell the defense how to phrase their mitigators, but
So you said there's case law that says mitigation can be the fact that if the defendant doesn't get the death penalty, that they will get life in prison?
yeah, there's a case, Ford v. State says that a life sentence, the fact that the defendant can have a life sentence could be considered as mitigation.
Okay, so Mrs. Curtis, you need to rephrase that so that it coincides with the case law, because...
Okay, we'll work on those two.
Please.
And then there's...
I agree that if the case law says it's appropriate, but it's about society being protected. That part needs to come out. We don't know what's going to happen. There's people in prison. I mean, he attacked a prison guard, so I don't think you can make that kind of leap. But the fact that the alternative would be...
But Your Honor, just to be clear, it has nothing to do with making the cognitive leap that, you know, he will be dangerous any place. It's just that the case law supports the proposition that a life sentence can be mitigating, and that's where the state wants to start and end its argument. It has nothing to do with future dangerousness, whether he's in prison or out of prison. We're strictly confining our argument to that a life sentence can be mitigating. And that is an important distinction for these proceedings.
Okay, so why don't you just put it exactly how the case law says you can put it?
All right, we'll take a look at that one.
Please. And are those your only objections, State?
Yes, Your Honor.
Judge, and I forgot, we did want to add another one that we forgot about, which is that Nikolas Cruz pled guilty to all charges and took responsibility for the crime.
Okay, Mr. Klinger, are you able to cut and paste those?
I can send them to him. You know, I don't know that he has a Word version of it, but...
If you send that to me, I'll send it. Easily take them out and cut and paste them.
So you're going to find another more appropriate paragraph to include rule out autism or rephrase that one, and then you're going to rephrase the part about the defendant serving a life sentence or what have you in a you're going to rephrase that. Okay.
Okay, so Judge, I do have a proposal for the autism one. Multiple mental health providers believe Nikolas Cruz had autism or autistic features. We haven't done the other one, but...
and where do you propose to put that?
We can put that, just insert it somewhere.
Well, Judge, I think we have to say that it was ruled out. I mean, I mean, the mitigators have to be reasonable. They just can't throw things out.
I don't know where it was pulled out.
Well, he wasn't ever diagnosed with autism.
Right, well, the mitigator says multiple mental health providers believe that he had autism or autistic features.
That's not true.
Not that he did.
There's no evidence of that. There's no evidence that multiple found that he had autism or autism features.
I remember, like, offhanded, I remember some things being testified to in maybe school records that perhaps you need to be tested for autism, but I don't remember any direct evidence. And maybe I just don't remember. Just remind me, who testified?
Your Honor, may I?
Yes?
So, if you remember, Dr. Weisblack made an indication that Nicholas needed to be further evaluated for autism or pervasive developmental disorder. Also heard testimony from Dr. Kravitz. He was the first doctor that the defense put on, that he believed that Nicholas's lack of eye contact and his limitations in social skills was consistent with a child that had autistic features. And Dr. Negan consistently said throughout his report, initially there was a rule out of the PPD, and then what happened was in 2013, the DSM changed and got rid of PPD, but his diagnosis was consistently issues with social skills and communication, which was also included in the letter that he sent to the school board. He has features of PPD, and then in parentheses he said social skills.
What is PPD?
Pervasive developmental disorder. Before they had the spectrum, and then in 2013 they removed that from the DSM. And Denny also agreed and provided testimony that Nicholas had features that were consistent with autism.
Your Honor, what Ms. McNeil said is a lot of people suspected he might have autism and looked into it. That's it. That's all is what Ms. McNeil just said. There is no diagnosis of autism. They all the people that she's mentioning, they just said maybe. And that's not a mitigator. That I suspect, he might have had this or a feature of it, but like Dr. Denny said, he didn't have it. Are there features of it? Yeah, there was one or two things, but that's not autism. And that's what everyone said. No one diagnosed him as autistic.
And then we would ask, Judge, if you were not inclined to give that exact language, that you include that pervasive developmental disorder was never ruled out and was included by multiple mental health providers, including individuals from Henderson. The state's own expert would include that in his evaluation. And then Dr. Negan, Dr. Kravitz, Dr. Weisblatt, all of those individuals said that. Sorry.
It's in out there already. You already have it.
If it's in there, then that's fine. I mean, we're not going to waive the issue.
It says pervasive developmental disorder is 26G. So they already have what they're asking for. There was no diagnosis of autism, and they admit that there wasn't, because the most they have is rule out, and that's not a diagnosis.
And that's not what we're asking to say. We're asking to say that multiple mental health providers believe that he had autism or autistic features. We're not saying he was diagnosed with it. We're saying...
But that's not true.
It is true.
You're telling me that multiple doctors testify that he has autism or autistic features? Who?
Not testified. Some of them testified, but it's in records that we put into evidence. The Social Security records, we did not have a witness testify, but we put those in evidence. Dr. Negan. Right.
It does not say he had autism. Ms. Curtis keeps saying that. There's nothing in any record that says he had autism. Is there a feature?
All right, a rule out is not a diagnosis.
I understand that, but what we're asking for the mitigator to say is, and we can leave out the autism, we can just say multiple mental health providers believe Nikolas Cruz had autistic features. We're not asking to say he was diagnosed with it. We're asking the mitigator to say that he had, that many of his providers believed he had autistic features, because then that's consistent with our argument that people with FASD have autistic features or are often misdiagnosed with that.
He wasn't misdiagnosed with autism. The argument doesn't make any sense. They're saying they're using it so that he was misdiagnosed with autism. He wasn't. He was never diagnosed with autism.
No, but the fact
They can say that the fact that he didn't look at me directly, that's an autistic feature. But it's not autism. It's an autistic feature. If there's a lot of other features, then it would be autism. Otherwise, it's just he didn't look at
And
me.
you can't outgrow autism, if I'm not mistaken. Can you? Because the doctors currently believe your client does not have autism. Correct? The
Right.
current evaluations say he's not autistic.
there's also an indication of autism, ADHD in the.
But I'm asking you, do the current doctors who evaluated him for hours and hours and hours, do any of them believe or did any of them testify that he has autism?
No one testified that he has.
Okay, and you can't outgrow autism, but yet you want me to instruct the jury that a mitigator is that he has autistic features, even though all of the doctors from both sides are in agreement that he's not autistic.
No, I'm not asking you to instruct the jury that as a mitigator he had autistic features. What we're asking for is, and even the state's doctor does agree that he has autistic features. Multiple mental health providers believed Nikolas Cruz has autistic features.
But he doesn't
That's
have
true.
autism.
That's, okay, we're not asking you to tell them that he has autism. We're asking you to tell them that
What you're asking is clearly misleading. You're asking me to advise them that a mitigator is that he has features of autism, yet he does not have autism.
No, that his mental health providers believed that he had features consistent with autism.
You can have features consistent with a lot of things. If you don't have the actual thing, it's not probative.
Well, Judge, the standard
It's misleading.
is very low in terms of providing mitigating evidence. So.
Which is why I'm giving them 36 or 40 paragraphs of all different things, including deficits in developmentally delayed, severe phonological delay, memory deficits, motor function delays, neurological impairment, social skill impairment, adaptive functioning deficits, executive functioning deficits, central nervous system abnormalities, independent functioning deficits, cognitive deficits, intellectual deficits, and so on and so forth, to suggest that he has autism when the testimony is in direct conflict of that is misleading, and I'm not going to do it. So that request is denied. All right, now when okay, so after you insert you make the changes, you're going to make the changes to paragraph 38. I've ruled on paragraph 26K. I'm deferring on paragraph 14. But other than that, we're going to go to the next paragraph where your decision regarding the appropriate sentence should be based upon proven aggravating factors. I see that the defense is suggesting taking out a few words to the standard language. Other than that, is there any objection to the standard instruction? Other than what you've written in green. And
No, I just wanted to correct, though, that in that paragraph, that short paragraph, the aggravating factors proven by the state beyond reasonable doubt, that should have been in green, but no other.
What should have been in green?
Well, so the standard instruction says your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances. But in my version, I took out proven in red, but then I forgot to put proven by the state beyond a reasonable doubt. We just wanted to reiterate the standard of proof again, and I didn't put that in green. That was my error.
Okay, I understand. Thank you for pointing that out. I'm going to give the standard instruction on that paragraph over the defense objection. The following paragraph, the next step in the process state, is your version the standard instruction?
Yes, ma'am.
And defense, you're suggesting adding a few sentences, the state has proven beyond a reasonable doubt, and you may always consider mercy in making determination?
Yes, ma'am.
And you agree those are not part of the standard instruction?
Yes, ma'am.
All right, I'm going to give the standard instruction over the defense request. The next paragraph, state, is that the standard instruction once each juror has waived the proven factors?
Yes, ma'am.
And the defense has added or suggested or is arguing for additional language in green that's beyond the standard instruction. Is that correct?
Yes, Judge, it's just to reiterate the standard of proof.
Okay, I'm going to read the standard instruction as to that paragraph.
I did make a change in the next paragraph, Judge.
Rather than, it looks like rather than saying you will be provided with a form, you're asking me to tell them you will be provided with 17 forms to reflect your findings and decision regarding the appropriate sentence for each count of first-degree murder.
Yes, ma'am.
Defense, is there any objection to clarifying that?
No.
Should we put 17 verdict forms instead of forms?
No, the standard instruction says form.
With
We
a
would just
form.
ask that the underlining and the italics.
Yep, take off the underlying and the italicize. Okay, and then you'll take off the footnote number as well as the actual footnote. Then the next paragraph, okay, so I'm trying to figure out where we should stop the designation of mitigating circumstances.
According to the Florida Supreme Court's instructions, the weighing of it begins with the next paragraph when considering.
Right, but there's a couple of paragraphs that fall on the state's proposed 10 and 11, which I don't think are part of mitigating circumstances. In fact,
The weighing process itself.
I think after the, so we're going to, Ms. Curtis, we're going to separate mitigation, the mitigating circumstances, separately where it defines mitigating circumstances, just like aggravating factors.
Okay.
It looks to me that after the mitigating circumstances are listed, that we should start a new page.
Okay.
Do you agree that your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances? I don't think that's part of the definition of mitigating circumstances.
No, that's fine.
Okay, so let's start a new page. Right there. On page 10. And then on the top of page 12, I want to add weighing the evidence in bold, like I showed you. Now, is there any objection to any of the paragraphs under weighing the evidence? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Is either side asking for that paragraph?
Yes, Your Honor.
Okay. How about, had any pressure or threat been used against the witness that affected the truth of the witness's testimony?
Yeah.
Yes?
Yes, we will have.
And has the witness been convicted of a felony or a misdemeanor involving dishonesty or false statement? I don't remember.
Well, we did have some witnesses.
Felony conviction.
Okay. How about a general reputation for dishonesty or truthfulness? Paragraph 10.
I don't think there was any evidence of that.
Is either side asking for paragraph 10?
No.
All right, so we'll take paragraph 10 out. And if you would please state, just put weighing the evidence page 1 of 2, weighing the evidence page 2 of 2, please.
Yeah.
Obviously, defense, you're asking for the paragraph that says the defendant exercised a fundamental right, correct?
Yeah.
Now, on the top of page 14, if you could please put bold in the middle, rules for deliberation. And you took out number 5 about the juries not to discuss any questions that a juror wrote that was or was not asked in court. You all took that out because we didn't do that in this case.
I don't see it in here.
I just want to make sure.
Steve,
I'm sorry, which one was that, Your Honor?
we took out the notes.
Right.
Yes,
I didn't allow the jurors to ask questions. I just want to make sure that was taken out.
Yeah, I don't see it in here.
Right. Oh, yeah, that was taken.
Okay, and then on page 14, where it says in just a few moments, if you can start a new page and put submitting case to jurors.
Submitting the case to the jury.
Or maybe just start a new page.
Okay.
Judge, if we could just go back, in our submission, Judge, we did red strike through on some of these rules. There's detailed arguments in the footnotes for that and for the ones that we wanted to add, all of them supported by U.S. Supreme Court case law for every one of these rules. And so those are the requests that we would be asking to add to the rules for deliberation. It's on pages 10 and 11 of our submission, and 12, I'm sorry.
All right, under rules for deliberation, I'm going to give the standard instruction. Now, where it says in just a few moments you'll be taken to the jury room,
In paragraph after that, I put that in there, that's, certainly however the court wants to handle the verdict forms. That's not found in the standard instructions.
what are you talking about?
Well, we went to the new page, right, for submitting the case?
A
Or
new
did you
page,
just say do a new page?
only because if both sides are going to take 2 hours for closing, we're going to end up with some extra time. So I'm going to read most of the instructions tomorrow when you're finished. And I don't want to say in just a few moments you're going to be taken to the jury room. That I'll probably read on Wednesday morning.
Oh, so you're going to read the instructions up to that point?
Or
Tuesday?
about to that point. I'm not sure exactly. I want to find a logical place to stop. Of course, I'm not going to say in just a few moments.
Okay.
Mr. Klinger, what did you say you added?
Your decision must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows.
This is a standard instruction.
But not, it's not in the Florida Supreme Court's penalty-based instruction, I don't believe. But I think you're right that it's included in the regular jury instructions.
Right, but it's kind of repetitive. On page 11, it already says you will be provided 17 forms to reflect your findings. So I just don't think it's really necessary to have that in there.
Well, I think it informs them that you have. They have to be. Every form has to be signed and dated. They have to go through each one, and I think it tells them that at least they're going to be printed for their convenience, but they'll know they have to go to every form, and it's up to the court. They're rather lengthy verdict forms. So it would be up to you, Jerry, if you want to read the version that applies to those counts that only have 5 aggravators, and then the version that applies to the count that has 7 aggravators.
It's 3.13, submitting the case to the jury. So you're saying that the death penalty standard instructions don't include 3.13. It says in just a few moments you'll be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The person should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict, and bring the verdict forms back to the courtroom when you return. It also indicates this instruction, or a version of this instruction, needs to be included because these are things that they need to know. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. Then it also says during trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations, and then it indicates that you either tell them that all of the exhibits or some will be sent into the jury room with you when you begin your deliberations. And then that's usually where I put accept, and then I put what's not going to be sent back, and I tell them if they want to examine those specific exhibits that are not going to be sent back, that they should let me know, and we will make that exhibit available to them to view in court.
It's in the states.
It is.
Yeah, all of that is there, Judge. It was just the verdict form that I was sort of leaving up to how the court wanted to handle that. The rest of it, you'll find that it's all there. Although we did add some things into the what would go back to the jury room and not go back, but of course the court, whatever the court's preferences on that is fine.
So the only part that you added is your decision must be in writing, and for your convenience, the necessary verdict forms have been prepared for you.
Next page, too.
Yeah, and the very page 16, the bottom of 15 and the top of 16, change some of the wording there.
Okay, is there any objection to the way the state has spelled out page 14, 15, and 16?
Judge, we're asking that either that we, instead of reading this, that we say, if you wish to see any exhibits, please request that in writing. There are boxes and boxes and boxes, and there's 20 of them. Or no, there will only be 12, but it's 12 people, but a huge amount. I mean, you either have to send it all back or none of it. I mean, you can't
Judge,
send some and not others.
Go ahead.
we'd object to that in that the evidence goes back. Our only restriction should be guns or ammunition, not both together.
Okay, is there a way, I think both sides had or we can copy what the clerk has written, an exhibit list so that they can okay, I've been thinking about this a couple days. If there's 500 state exhibits, let's just say, how are we going to, shouldn't they be in some kind of order so they can find, like 1 through 100, 101 through 199, or whatever it is? And the same for the defense?
I think they are in order.
I'm reading one objection.
But
We have no objection to giving a list, the clerk's list with them, but they should all the evidence should go back. Otherwise, someone's going to have to remember a piece of evidence, identify it before they can get it. That's not how it should work.
We don't have an objection as long as they're given all of it, except for not the gun and the ammunition together and no biohazardous material. That's fine as long as they have all of it, all those boxes of records and evidence, and we can provide a list also.
what biohazardous material was sent back? I'd rather tell them exactly what it is. Like DNA swabs?
Did we introduce DNA swabs? Yes. Yeah. There might. I guess there's DNA swabs.
But they're all packaged.
They are all packaged. Yes.
And they're in like they're not just packaged, aren't they in sealed bags? I don't remember. Is it, okay, so is it just DNA swabs?
That's all I can think of.
That would probably be the only thing, and I'm not even sure if we're going to enter them and then maybe.
Okay, I would just ask that you go back through and list specifically what won't be sent back. Ammunitions and weapons will not be sent.
Yeah. They can have the ammunition or the gun and just switch it. Easiest is to just give them the gun first and then the ammunition if they want it afterwards. It doesn't matter.
Okay, so then I would like to say the firearm will be sent back and explain that it is, what is the word? It is
Made safe.
Secured.
so that it cannot be discharged. However, we will not be sending back the ammunition unless, if you want to see the ammunition, you need to make that request in writing. And then rather than
Give us back the gun.
Excuse me?
And then they'll give us back the gun.
Okay, and then rather than no biohazardous material, I'd rather that you list those things, please, whatever they are. You know, items A, B, C, and D will not be sent back into the jury room. If you wish to examine those exhibits, please put that request in writing. And then now, Ian, don't we have a way for them to listen to digital recordings? We have
There's a system in there.
okay, so perhaps you all should go look at the system that we have. It's blank, so it doesn't have any.
He has no access to the internet, nothing, all they can do is put it up and play it up.
Okay, we have a system in the jury room that was put in by court administration when the new courthouse was built, has no internet access or access to anything other than it will play a digital recording via a zip drive. Is there any digital evidence that is on something other than a zip drive, like a DVD or CD? I don't.
Yeah, there are discs.
I'm sorry?
There are discs.
You can? I think that you should pick one lawyer from each side to go back there with Ian to test this stuff out, to make sure it's simple and no further instructions are needed.
Judge, could we also have an agreement from both sides that Ian can go back with the jury initially just to show them how to use the equipment?
Sure, I think that's a good idea. And we can do it before their deliberations begin, before the door is closed, before, you know.
Yeah, he wouldn't listen to anything.
Correct.
Just show them how to use it.
Is there any objection?
No.
No?
For Ian to go back with them?
Before they begin their deliberations, to give them a brief tutorial on how to use the equipment. I'm assuming out of 12, there's probably one that's pretty savvy with computers, just because usually more than 1 out of 12 are, but who knows? I think that's a good idea. So there's no objection from either side, correct?
There's no objection from the defense.
State, no objection.
No objection.
Okay. So we're going to... Is there any objection to a list? Okay, so my question is this. If they want to hear, let's just say, one of the, recording 3 that was played during Dr. I don't remember his name, the second to the last expert. What was it? And I'm trying to pick something.
Dr. Denny. Dr. Denny, and we played some clips from the...
Who was the one before that?
Dr. Scott.
Dr. Scott. Let's say they want to hear clip number 3 from Dr. Scott. And there's all this evidence sitting there. How are they going to find that? I'm trying to pick something that's not fresh in everyone's memory so that you all see where I'm going here.
Well, will we give them a list of the items and evidence?
Well, that's my question. We need to do something because there's so many things from both sides that if they come up with, I want to hear this or that, there should be a starting point. Can we see your evidence list, please? I am open to suggestions. I don't know if this list is going to be enough. If you all want to take a look at it. Sure. It's a little messy. Do you want me to email them to everybody, including yourself, Your Honor, and you can see my list and see if that's useful?
Are we on the record?
No, it doesn't have to be. Why don't we take a 10-minute recess? And there are a couple motions pending.
Before we do that, on the verdict form, we are also making a request to list the mitigating circumstances on the verdict form. And that has been done in previous cases.
That was the way they were done just after first, but one after Perry, in that period afterwards, the Florida Supreme Court then changed the jury instructions and no longer required that the mitigation be listed in the verdict form. That change was made by the Florida Supreme Court, I believe, in 2018, and they have not deviated from that course. And as of now, all they require is for Section C to read one or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence, yes or no. And they do not require any other list.
I can't hear you. Would you speak up just a little bit, please?
Sure, sorry. If you look at number C in the verdict form, probably use the third page. Okay. Where it says mitigating circumstances.
Okay.
Prior to 2018 and after first, you would have to list the individual mitigators and what the votes were on the mitigation. That was taken out by the Florida Supreme Court. And the only thing that they've asked to put in now in the standard instructions is what you see on C, where it says mitigating circumstances, one or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. And it's been that way for the last 4 years.
Okay, I am going to use the standard verdict form. However, if these pages get mixed up in the jury room, I don't know how they would put them back together. I would like to indicate somewhere, maybe it can be, I think there's a way you can put right next to the page number at the bottom, count one, Luke Hoyer. That should say that on each page for each of the victims, so that, well, I see that his name is written in some of the paragraphs, like on page 2, but do you all see what I mean?
Yeah, no, that's...
There are 17 victims. If the pages
we can fix that.
get mixed up, I don't know that, I think only page 1 and 2 say the specific victim's name. Do you see what I'm saying?
Yes, I know, I understand what you're saying. We can fix that. That's not fine. The name will be...
If you can put the count, just count 1, Luke Hoyer. Count 2, Martin Duque. But make sure it says it on each page so that, like I said, if they get mixed up,
No problem.
they can keep them together. Please. Is there any objection?
No.
You see what I'm saying? Only the first 2 pages list the specific count. So I just imagine myself going through all of these things, and if some of the pages are not kept in the exact order, that way they can refer to them properly.
Because even though it's not required any longer, we are requesting that the mitigating circumstances, we can we're asking for mitigating circumstances be listed on the verdict forms. And we're asking that each one be listed with a vote or the number of how many jurors found it and did not find it. And the reason is that once a mitigating circumstance has been established, the jurors must consider it. There's no direction as to the weight they have to give it, but they must at least consider, and this would reflect that they did consider it even if they didn't give it weight.
And that was the way it was for a short period of time after Hearst, until the Florida Supreme Court decided that it no longer needed to be that way, and they changed the standard instruction to no longer include having to list the mitigator.
And the standard instruction is what you have proposed?
Yes, ma'am.
Other than the change that I want that the count be listed on each page so that the verdict forms do not get mixed up.
Yes, that's correct.
All right, I'm going to give the standard verdict, use the standard verdict form as recommended by the Florida Supreme Court, or as used by the Florida Supreme Court.
Your Honor, did you intend to read every verdict form separately? I don't think you need to. I think you can do it in two groups. There's 14 of the verdict forms read identically, except as to names, it's all the same with the aggravators. And then 9, 11, and 12 could be the second group.
Okay, so what I will do then is I'll read one verdict form for the first group, which begins with Luke Hoyer, and I will say this verdict form applies to victims, and I will read the names of the victims and the counts that it applies to rather than reading it 14 times. Does that make sense?
Yes.
And then as to the 3 individuals who I would call adults or employees of the school, I will read their specific verdict form, and I will indicate that this specific verdict form is identical for the 3 victims, and I will list those victims and their counts. Okay.
Your Honor, just one more thing to the record regarding jury instructions from
Sure.
the defense, please. Just want the record to reflect that the state had requested alterations to the standard instructions 10 times, and those were all granted, and the defense in 14 areas of standard instructions asked for alterations, and they were all denied.
Okay, moving on to the motions. The motion eliminate to prohibit the state from mischaracterizing trial testimony during closing argument. Is there anything you want to add to your written motion, defense?
Your Honor, I just wanted to highlight 2 things, if I may.
Sure.
Please. So we are asking that Your Honor prohibit the state from describing Mr. Cruz as a sexual predator or referring to any of his past conduct as sexual molestation. As you recall, and we've talked about it many times, there was perpetuated testimony by defense witness Danae Browd where she talked about the inappropriate touching that happened with her daughter. And then there was a second witness.
State, are you in agreement not to use the word sexual predator?
Yes, Judge, we will use inappropriate touching. That was the first.
All right, that's granted.
Thank you.
Is there anything else in this motion? I think that's all that
That was all that was
addressed.
Thank you.
So there's 2 motions left. Defense, corrected motion to preclude the death penalty based on prosecutorial misconduct in attempting to interfere with defense presentation of mitigation. Defense, is there anything you wanted to add to your written motion?
No, Judge, it's all in the written motion.
State, is there anything that you wanted to argue, or I don't think you filed a written response, but is there anything you wanted to?
We did not, Judge. There are some things I'd like to put on the record.
Okay.
With regard to Jack, I think it's Vese, V-E-S-E, I'm sure the court remembers this issue had already been litigated and it was actually in front of the jury. The issue of the phone call that took place the morning of
September 1st with Mr. Marcus and Christopher Whitlock, which is Mr. Vesey's attorney. As the court is aware, it's entirely proper for a lawyer to talk to a witness before they are called to testify. The fact that Mr. Vesey got the impression that, and it's his subjective interpretation, that somebody didn't want him to testify, that was not the subject of the call. To the contrary, the subject was, what are you going to testify to? And it doesn't even appear that Mr. Marcus was on the call during that time. On cross-examination, which is conveniently omitted from the defense's motion, and this is on the trial transcript, page 7889. This is September 1st, the cross-examination of Mr. Vesey. I asked him, you're aware that it's permissible for lawyers to speak with witnesses, right? He answers yes. I asked, okay, and you testified that you were concerned this morning, or that your testimony, or whoever was on the phone, that your testimony would negatively affect individuals within the Broward County School District. His answer, yes. I asked, but that person was just Mr. Whitlock, correct? And he answered that I was worried about Mr. Whitlock. Question, Mr. Whitlock was worried. He was the one concerned about your testimony. Answer, he voiced that. Yes, he did. He's the one that voiced that. Okay, not Mr. Marcus. The answer, no. So the only person that could have made him feel nervous about his testimony would have been Mr. Whitlock, and it wouldn't have been anything that Mr. Marcus questioned him about. So I just reiterate that it's entirely proper for a lawyer to talk to a witness before their testimony. Certainly doesn't arise to the level of prosecutorial misconduct. And lastly, we were getting lists, as Your Honor knows, after 5 p.m. the night before witnesses were called in the mitigation case. So the only appropriate time for Mr. Marcus to have the conversation would have been that morning before he testified. So there's absolutely no prejudice established with regard to that Mr. Vesey's testimony. As to Dr. Andrew Ackerman, and I just want to let the court know, I plan on reading from the statement that had been previously subject matter of it being sealed when we filed a notice to the court after the Deliberation hearing was canceled, and it was in part, this statement became part of that issue. Dr. Andrew Ackerman was a radiologist that was, a neuroradiologist who is hired by Acumen, which is the agency that does MRIs and PET scans and so on and so forth. On the day that the defendant got his MRI, which was November 30th, 2021, Dr. Ackerman was randomly assigned to interpret it. So first and foremost, in their motion, in paragraph 14, the defense claims that this phone call to Dr. Ackerman with a defense-hired expert, that's really disingenuous because they didn't hire Dr. Ackerman. Dr. Ackerman was on this by pure chance. So, and again, this is in November. Then in March of 2022, it turns out that their defense-hired expert, Dr. Richard Adler, called Dr. Ackerman and said, hey, I have all these different reports, a brain triage report and DTI reports. You should take a look at them. And by the way, I'm Dr. Adler, a renowned scientist in fetal alcohol spectrum disorder. Dr. Ackerman thought it was rather strange. Meanwhile, we were not made aware of this phone call or any of this communication. During that time, Dr. Ackerman was not listed as a defense witness, and my office was making attempts to speak with him. On June 9th, and because of that, the defense filed him as a witness because they wanted to be part of the deposition. Then, after he was listed on June 9th, our office began trying to coordinate with the defense to take his deposition, and they tried to stop it by claiming there was a non-disclosure agreement. That has nothing to do with us. That has to do with Dr. Ackerman and the defense. And the MRI report had been disclosed months and months before. So you can't hide behind a non-disclosure agreement because you don't want to participate in the subpoena. And then fast forward to June 22nd, 2022, we get a letter from Dr. Ackerman, and I will have it as an exhibit. And I would just like to read it into the record. This letter is to state that at the time of my original report, I was hardly given any information on the patient. In fact, I later learned that there were additional sequences performed that were never provided to me. Most times it is typical that we receive incomplete information from imaging centers, and as a result, in this case, my original report was based only on the information I had at the time. Although my report indicated that the original neuroquat sequences showed no visible significant abnormalities, that report was written without the benefit of having access to quantitative DTI and NQ data, nor the brain triage atrophy report. These missing sequences were given to me at a later date, and I was asked to amend my findings. At that point, I no longer felt comfortable with providing the quality of report I am accustomed to providing. The missing information has tainted my original assessment and biased me from doing any further objective analysis. This statement was the product of Dr. Adler calling him and trying to get him to change his report. And we learned that at Dr. Adler's depo, which was, I believe, August 5th, 2022. And after we took the deposition from Dr. Adler, where we learned that he had in fact made this contact and had these emails, we set Dr. Ackerman for a pretrial conference on August 11th, 2022. The defense removed Dr. Ackerman from the witness list on August 5th, 2022. So he was no longer a listed witness on August 11th, 2022 when we took the statement from him. The accusations that they made in their motion, paragraph 16, for example, on August 11, 2022, the date of the pretrial conference, defense counsel advised the state that Dr. Ackerman had requested that the defense counsel attend the pretrial conference. Not true. If you look at the statement, Dr. Ackerman's statement from August 11, 2022, on page 24 of that statement, I asked Dr. Ackerman, okay, all right, have you been in contact with Dr. Adler at all since the last conversation? He says, I have not had contact with anyone. Question, okay, anyone from the defense team? Answer, anyone from the defense? Right. So obviously there's been no conversation between the defense and Dr. Ackerman before he was prepared to give her the statement to the state on August 11, 2022. As far as the paragraph 19, it suggests that there were multiple conversations between Dr. Ackerman and my office. Again, that's untrue. The only conversation that went back and forth, it wasn't a conversation, it was scheduling. It was emails trying to get my office and Dr. Ackerman's office on board for a date that was convenient for him for a statement. I had never met, nor had anyone from my office met or spoke to Dr. Ackerman prior to August 11, 2022. I don't understand what even anything in paragraph 20 has to do with the motion, but what it doesn't contain is exactly what went on during that statement. And I'd again refer back to the statement that Dr. Ackerman gave. And I asked him, okay, so this study, this is page 9. Okay, so this study was done on November 30th, 2021. And when you got the image, were you also provided the neuroquat sequences? And Dr. Ackerman responded, there we go. Sorry, we had a little bit of a delay. I got also, I'm not moving anywhere. But anyway, having said that, just to finish the story, this is where it gets really annoying and frustrating, is that I always ask for as much history as possible. And the more history I have, or if I have any prior
slow down, just a little, please.
Those are always a radiologist's best friend. And the more information I have, the better assessment I could get. Out of nowhere, I get this phone call from this gentleman from Seattle, okay, and he's supposed to be some famous neuro-schmuro, whatever, big name in neuroscience. I've never heard of him, but that doesn't mean anything. I mean, he's like practicing in the Northwest. So this is why I felt a little bizarre, because not only did he provide me with the quantitative data, which it's like, why the hell did you get that, and why didn't I get this in the first place, but he was pointing towards figures in the quantitative data that would show me why they were subtle differences. And I'm thinking, is this guy trying to talk me into changing my opinion? So that's why I'm like, all right, this is too much. I just want out of this. Like, I got half a study. I interpreted it the way I could. Now I'm getting all this quantitative data. Plus he's the one that told me, like, all this family history, like fetal alcohol syndrome and all this other nonsense. Why didn't I get that in the first place? And I continue on again, page 23 of that statement. Okay, and to be, you've said this, you felt that Dr. Adler was trying to get you to change your report. Answer, well, I don't want to throw him under the bus. My question, put it in your own words then. His answer, essentially I felt that once I realized...
Ms. Giappelli, just if you could, you're like over 300 words a minute, just a little bit slower, please.
Essentially, I felt like once I realized what was going on, I felt like the defense was trying to push me in a certain direction. So clearly the state wasn't doing anything improper by questioning this witness when it received information that one of the defense experts had called and tried to get Dr. Ackerman to change his report. Being upset that you weren't invited to our pretrial conference doesn't give you a right to make accusations of prosecutorial misconduct. Lastly, Judge, I just point out that the case law in the motion is not applicable whatsoever. The Dent's case, the alleged interference was a Department of Corrections investigator who promised a defense witness that he'd get parole if he refused to testify. And in the Hammond case, this is an FBI agent who approached a defense witness while the court was in recess and basically threatened him. This witness had an indictment pending in Colorado. He said Colorado's going to go real bad for you if you continue to testify. So these facts have nothing to do with what's going on here. None of this was preserved, and these witnesses didn't testify. So there is no prejudice. They also didn't file a motion to quash the subpoena, which they could have done. They knew we were going to speak to Dr. Ackerman on the 11th, and if they wanted to stop it, they had a remedy to do so, and they chose not to. So we're allowed to talk to witnesses. There's no prosecutorial misconduct here. There's nothing improper that the defense or the state did. So I would ask that this motion be denied. I wanted to just make a record, and I would like to move in the documents that I referenced to. I have them marked as states 26R, 26S, and 26T, so that the record is complete.
You want those as court exhibits, so no?
Yes.
You're not going to go to the jury,
Yes,
obviously.
correct. Yes.
So, what? Wait, when the lawyers were up here looking at,
8, 9, and 10.
I just got blamed for something. Is going to be received as Court Exhibit 8, 26S 9, and 26T is 10.
Judge, may I respond briefly?
I asked you if you had anything to add to your pleadings, and you said no.
Well, no, I just have a response to...
Okay.
Okay, so first of all, and I don't understand why the state keeps saying this, because Mr. Vesey made it perfectly clear. Christopher Whitelock is not his attorney. He's a private attorney. And in fact, Mr. Vesey testified he's been retired from the school district for 6 years. So there shouldn't be any confusion. Mr. Whitelock is not his attorney. And I would find it hard to believe that he would represent that he was his attorney. Second of all, it doesn't really matter whether it was Mr. Whitelock or Mr. Marcus that was saying things to Jack Vesey like, what you say could have implications for the district or implications for people that are friends of yours.
How can you say that it doesn't make a difference? If Mr. Marcus wasn't even on the phone when that was said, how can you possibly say that doesn't make a difference?
Well, I don't know that there's evidence that he wasn't on the phone.
Mr. Marcus said he wasn't on the phone.
I understand that, but what Mr. Vesey said is They were concerned about the testimony that I was going to give and how it might implicate other people, is probably the best way I can put it. He didn't say Mr. Marcus left the call, so at best, we have Mr. Marcus standing by while another member of the Florida bar is trying to pressure a witness into taming his testimony.
I don't disagree with that, but what Chris Whitelock said, for whatever reason, what does that have to do with Mr. Marcus?
Because if he's on the phone and that's going on...
He said he wasn't on the phone, and your witness doesn't know.
Mr. Vesey said that they were on the phone. He said that they were both on the phone.
He did not say that.
I'm reading the transcript. They were concerned about the testimony that I was going to give.
But
and how it might implicate other people.
When he was asked who said those things, he said Chris Whitelock said them.
Right.
And then Mr. Marcus said he wasn't on the phone when that happened. So what you're asking me to do is presume that Mr. Marcus is lying and that he was in cahoots with some school board lawyer who, for whatever reason, said something to a witness that was, I don't know if it was inappropriate or not, because I don't know exactly what was said.
Well, I don't see what motivation Mr. Vesey would have to make this up. He said he got a call.
I'm not saying he made it up, but what he said was Chris Whitelock said X, Y, and Z to me. Mr. Marcus is representing that he wasn't on the phone when those things were said. So what does this have to do with Mr. Marcus?
Because Mr. Vesey testified otherwise and said that Mr. Marcus was on the phone. And if Mr. Marcus hears another member of the Florida bar trying to pressure a witness into changing his testimony or not testifying, then he should have immediately terminated the conversation and reported it to all of us right away, and that never happened. And that's the best case scenario, that he listened while it happened.
He said he wasn't on the phone. Did the gentleman not call the witness before he spoke to Mr. Marcus? Isn't that what happened?
Yes.
Mr. Whitelock called the witness and then conference called Mr. Marcus.
At the request of Mr. Marcus. Why would Mr. Whitelock call him without being requested to do so?
Of course, he said he asked him. He wanted to speak to a witness before he testified. There's nothing wrong with that. In fact, the rules say otherwise. So you're going from one extreme to another. I'm not going to make a judgment as to whether or not Chris Whitelock said something that was inappropriate, because really that's none of my business. But if Mr. Marcus wasn't even on the phone for that part of the conversation, you want me to throw out the state's death penalty case because of something that another lawyer did?
Yes. We're asking that this court preclude the state from seeking death because Mr. Marcus was on the phone, and I understand the court is saying no, but Mr. Vesey testified otherwise. They were concerned about the testimony that I was going to give and how it might implicate other people is the best way that I can put it. He named him by name, Judge. He's indicating Mr. Marcus is on the phone, and even if Mr. Marcus didn't make these statements to him, he stood by while someone else did, and that's unacceptable. That is improper, and I don't have the information about the other witness, but this is now a pattern. We also have, and we didn't include this in the motion because we don't have enough actual evidence in writing, but there are two other witnesses who were going to testify that refused to testify either because of
Judge, this is not part of the motion.
I'm sorry, guys, one at a time.
To get to this.
I'm going to sustain the objection. Is this part of your motion? I mean, there is a pattern, and I will say that the amount of times that the defense has filed a motion alleging prosecutorial misconduct is more than I have ever seen in any other case. At least 5 or more times you all have filed those types of motions.
Judge, we file motions we feel are appropriate and we feel the circumstances warrant.
All right, your motion is denied. What is left?
Judge, the only thing that's left is the state's motion in limine that I filed. It's SF-227. It basically pivots off the motion that Your Honor just denied to preclude disparaging comments directing at opposing counsel. And I filed it because I suspected that this issue coming up about Mr. Marcus trying to suggest that a witness not testify or change the testimony would be mentioned in closing argument, and that's entirely improper. And I would cite into my motion, disparaging comments attacking counsel personally are strictly prohibited, and that's Frankie v. State at 59 Southern 2nd, 82, citing Brooks, 762 Southern 2nd, 879. As the court has heard multiple times now, it's entirely appropriate for a lawyer to talk to a witness before their testimony. That's what took place. The defense has no right to get up before this jury and say that anything was improper was done by anyone at this table.
Before I even get to this, I want to say one thing. Throughout this trial, I have made rulings which have not been respected, and things that I have said are not to be asked have been asked anyway. I want to say that after today, if I rule that certain things are not allowed to be mentioned, or if I have previously ruled they're not allowed to be mentioned, and they are mentioned, and this is fair warning, I am going to reprimand either side if you do this in front of the jury. I'm going to say, Ms. Bailey, I have told you not to say that, and I'm going to tell you again, the jury is to disregard that statement. And that is fair warning. I'm using my lovely court reporter as an example because I don't want to be accused of picking on either side. But if either side gets into something that I have said is not admissible, that's exactly what I'm going to do. So I'm going to assume it's a strategy of yours and you do not care whether or not you get reprimanded in front of the jury. I'm going to assume that's some type of strategy that you have specifically chosen, and if you are going to do that, I would ask that you please think about that, and if it's the defense that's going to do it, please speak to Mr. Cruz before you do that so that he is on board with any strategy decisions that you may or may not make. Is there anything else about this motion?
No, Judge.
Defense, do you want to respond?
Yes, Judge. The defense is fully aware of the instruction and that the court would give to the jury, and that lawyers are in fact permitted to speak with witnesses.
Okay.
What Jack Basie testified to, which is in evidence, which 20 members of the jury heard, was how that call made him feel. And he testified under oath that Mr. Marcus was on that call. And the impression and the feeling that he got made him very uncomfortable. He also testified that he felt like they didn't want him to testify. That is not disparaging on anyone. That is exactly what this gentleman testified to, and that is what is in evidence, and the jury can draw any conclusion that they want to from his testimony, just like they can draw any conclusion from any other witness about their testimony. This is already in evidence, and this is the impressions that this gentleman felt as a result of a phone call that he received, and under oath he testified as to who was on that phone call. So that's the only thing that we may get into. I'm not going to point a finger at anybody. I'm not going to say that anything was improper. I'm just going to say, how did that call make Jack Basie feel? And that's exactly what he testified.
You can argue any facts and evidence, but don't summarize them and don't ad-lib, because the arguments that I'm hearing from your side is summary and ad-lib and your impressions. If you want to argue facts and evidence, you make sure it comes directly from the transcript, because if it's not accurate, you can't say it.
That's fair, Judge. I'll read it from the transcript.
Judge, may I just make one request?
You may.
If that argument is made or statement is made regarding how it made him feel, I would just ask that the court read the instruction that at that time that lawyers are allowed to speak to.
That's part of the standard instruction. I intend on reading it. I intend to read it. I'm not going to read it at that exact moment. But again, make sure the exact argument comes from the record and nothing more.
No.
All right. Is there, other than I would like one lawyer from both sides to please go with Ian do we have any exhibit that we can use so he can... Can we have a thumb drive and you said there's a DVD also? State, did you say there's a CD or a DVD?
Yes, there are some, I don't remember.
Okay, well let's try to take one of each item and have one. tomorrow. My boss says we can't do it today. Is that okay with you all? Yeah. We're going to have plenty of time tomorrow.
You're on, what time tomorrow?
I told the jury 8:30. I'd like to start right at 9 o'clock with closing arguments.
Thank you.
So, Your Honor, I have a question. If Mr. Satz concludes his deposition at 11, his closing arguments, do you want me to go right into mine?
Please.
And I'm going to request maybe 15 or 20 minutes between our arguments so that I can check some stuff.
That's fine. Also, I can ask you all in the morning, in the abundance of caution, how much time you want and whether or not you want a warning, and if you want to knock, if you want me to just say 15 minutes.
Judge, I'm not going to need a warning. I won't need that, and I can't tell you specifically exactly how long it'll be.
Okay, well, then the state can tell me how much time they need, and then that's how much time I'll give you. I mean, I need to know, I don't need to know exactly, but I need to know about how much time.
Well, I'm going to ballpark it around 2.5 hours, but
Okay.
I just want you to know I can't.
Okay, that's fine, that's fine. So 2.5 hours.
Because I'm still in the process.
No, that's fine. So both sides get 2.5 hours. Will that
And then at the conclusion of closing arguments, we'll review the revised
Yes.
jury instructions.
Yes. And depending on how long Mr. Satz takes, if he does take 2.5 hours, then maybe we'll break for a short lunch before. Just depending on if he's shorter, if he finishes early, we'll just play it by ear. I don't want to take lunch at like 10:30, but.
Okay.
Okay.
Thank you.